All right, we're going to get back with our next panel, practicing in the COVID era. This is obviously a challenge for all of us. This next panel is hybrid, with 2 people on the screen and 2 here in the room. Hybrid programs present their own set of difficulties. So the panel is going to discuss the administration of cases and experience of practitioners in the COVID era, particularly the use of remote hearings and meetings in judicial proceedings. And the panelists will discuss the use of technology in proceedings, remote participation by creditors, including at creditors meetings, on relevant legal issues implicated by the remote platform, including due process and forum nonconvenience questions. So our moderator for the program is Lisa Laukitis from Skadden Arps, and she handles distressed mergers and acquisitions as well as various financing arrangements. She litigates disputes related to the use of cash collateral, DIP financing, sales under Section 363, modification of labor agreements, retiree benefits, and plan confirmation. From my own experience over the last year and a half, I think we've made a lot of progress in terms of remote hearings, and I've benefited from input from practitioners as well as other judges, and I'm looking forward to hearing what our panel has to offer. Lisa, do you want to begin?
Sure, thank you very much. Yes, I'm Lisa Laukitis from Skadden Arps, and I'm pleased to be able to moderate this panel today. We have 2 virtual attendees. Denis Ferland is a partner in the insolvency practice of Davies, Ward, Phillips, and Vineberg, and he's based in Montreal, Canada. Benno Strub is counsel at Schellenberg, Wittmer in Zurich, Switzerland, and he'll be covering the restructuring issues in Switzerland, plus providing some insights on neighboring countries of Germany, France, and Italy. And Romo, here with me in person today, is the managing partner of SOELI Consulting, and he also specializes in insolvency and restructuring and is based in Mexico City. So the stories in each of our countries are varied in terms of what happened during the pandemic. We're going to start by giving a brief overview of what our practices looked like and some of the challenges that we saw and the changes that were implemented during the pandemic. We will also discuss some of the judicial and legislative impacts and changes that happened that helped in some jurisdictions and maybe left a little bit of room for improvement in others. We're going to talk about some of the themes that really stood out to us across all jurisdictions and the pros and cons of some of the developments. And then we're hoping to wrap up with a discussion of what worked, what did we learn, and what can we take from the developments over the last year and a half to try to move things in a better direction going forward and take advantage of some of the adaptations that have happened. So I'll start with a short discussion about what happened in the United States, and I have to say things were pretty seamless here. We really have to hand it to the judges, especially those in the primary filing jurisdictions of New York, Delaware, and Southern District of Texas. While there were some hiccups I felt early on in just figuring out the logistics of how do we deal with the hearings, how do we get evidence and entered and in front of everyone that's participating in hearings, there was the ability to get emergency relief basically all the way through in what was a very busy restructuring market in the United States. Companies were able to get relief and to get restructurings done. So we're very appreciative to the U.S. courts for that. Hearings are still largely virtual, and it will be interesting to see when things start to go back. But Denis, why don't I pass it over to you for a discussion of how things went in Canada?
Thank you, Lisa. Good morning, everyone. I wish I could be with you in New York. The next time around, I'm sure that we will all be in person. Well, in Canada, COVID hit in March 2020. And I keep saying that I never had in my agenda any inscription saying COVID will begin and there will be a pandemic. A little more than 18 months later, we're still under sanitary restrictions. In Canada, and I'll make it short, there's really 2 insolvency and restructuring statutes. the Bankruptcy and Insolvency Act and the Companies Creditors Arrangement Act. The reason I'm making a distinction is because all the filings for the Bankruptcy and Insolvency Act were all done electronically, and it's been the case for a long time. Filings for CCAA or for court proceedings were still done with paper. Service was done through emails most of the time, but you need paper. We needed paper copies to actually do a proper filing. The courts never stopped. We went from in-person hearings to virtual hearings. I wish I could say that there was no hiccups. Like anything that changes, there's always hiccups. But the courts and the professionals adapted very efficiently and very quickly to this new reality. The judges, we have a committee called the National Judiciary Working Force, and they got together, and that includes judges from all the provinces, so from across the country, and they worked together to make sure that the transition was as seamless as possible. It resulted, and I'll talk about it later, into a national order or an order that was recognized in all provinces to extend the delays. The Office of the Superintendent in Bankruptcy extended the delays when needed. The courts were really proactive, and really it was somewhat seamless. There has been guidelines issued by the courts for virtual hearings. Now we can file electronically in most of the provinces. So I have to admit the pandemic was terrible, COVID was terrible, but there are good things that came out of it. And the virtual hearing is one, the electronic filing is one. To some extent, the access to justice has to some extent improved, make it less costly, easier. The rule is still that virtual hearings are really what is first taking place. If people want a hearing in person, it's the exception. It's still possible, although it's not what the courts prefer. So as a summary of what happened in Canada over the last 18 months, I'll start with that and I'll expand later with other measures.
And it seemed like you had a benefit in Canada in making that transition because you already had a process where many rulings were already happening on the papers, right? If things were uncontested, it didn't require a hearing. And so, whereas in the US, we tend to have a lot of hearings on administrative matters and uncontested matters, that's not par for the course.
Actually, that's something that evolved during the pandemic, where we went from all hearings being in person to hearings being virtual. And when not contested, judges would agree to basically render their judgment only based upon the written documents. And it helped a lot, and it makes things easier and more efficient and obviously less costly. So that evolved during the process.
So staying on North America, Yvonne, Mexico had an extended lockdown during the pandemic, and there was no access to court for a long period of time. How did that impact what you were able to achieve and what companies were facing that needed, insolvency proceedings and relief from the court?
Yeah, I do believe that nobody was prepared for the COVID. So some countries were more prepared than others. In our case, we have three phases of the proceedings. The first one, as you said, was a total lockdown in which nobody can have access to the courts, notwithstanding it was administrative, civil, commercial, or bankruptcy issues. It was totally locked down that endures around 4 months, and you know what that means. less work for everybody and less employees and all the problems that it has becoming with that. And after that, the courts realize that they cannot continue with that issue. So they go into a season in which they will, in bankruptcy issues, will giving provisional measures only to solve the urgent measures that has to be given for insolvency companies. Also, the rising of insolvency companies was another issue because all the companies that were in different types like tourism or leasing or something like that were going down into the business. And it was necessary to give immediate relief for those kind of issues. And the courts start giving provisional remedies to these issues. But the problem was what has to be considered as a provisional remedy and that's to be given to the companies. And nowadays we have an hybrid mixture of the judicial process in which the courts are working half a time in open doors, attending practitioners and persons, and the other half of the time they are working in closure. They work attending cases and prosecuting the cases, but they do not see people, hearings cannot be happen, and it's still an ongoing issue in Mexico.
Right, and you were really starting from a completely, hard copy filing system, right? So that was
Right.
must have been a big challenge to go from having to get things stamped in paper form to trying to shift to online.
Yeah, that was very difficult. But to be fair, it was not a COVID issue. The only restriction. It was before the COVID area that Mexico was trying to modernize their process, and we come from a rigid law regime like the French one, and we need to file everything in hard copy.
Mm-hmm.
And with the courts not attending in person, it was very, very difficult. So the courts, mostly the federal courts, have implemented an electronic process to filing digitally. But at the beginning, the courts ask for the filing in digital, but a ratification of the hard copy when the court is open. So it generates the same delay because it doesn't serve anything if you file electronic and then you have to go to the court to file the hard copy. And nowadays, what is going on with the same IRS seal, you file the documents before the court and you can have access to it. But the problem is that not all the persons have this IRS seal to verify the documents.
And with that extended lockdown and no access to the courts, did you feel like that led to more liquidations for companies that were facing challenges at the start of the pandemic?
Yes, for sure. The main problem is without access to justice, you cannot have any solution. So small and medium companies, as we were hearing in the previous panels, were the most affected. And there are a lot of companies that go bankrupt without even knowing it. You cannot have a record of how many companies have been liquidated in these 18 months.
Benno, you had a fairly different story in Switzerland, right? You did have a short lockdown at the start of the pandemic, but then things pretty quickly returned to normal in all respects, right? Not just in the court system. Why don't you tell us a little bit about what happened there? Benno, I think you might be muted.
Thank you. Yes, no, I mean, we were not different in the effects of the pandemics as such, but if you look at our court system and then insolvency system, the response and it was a little bit different. During the first wave of the COVID pandemic, Switzerland took same or similar measures and at the same time and many other European jurisdictions. I will provide a brief overview on these measures in a minute. So the main reason why things perhaps went a little bit differently in Switzerland than in some other countries, as we have already heard now, was probably that the Swiss insolvency law provides for very few hearings. For the most part, proceedings are conducted in writing. This may seem unusual for the North American practitioners, but this is really the way we are doing things here. So the challenges posed by the initial lockdown in March and April 2020 were more of a functional nature. So particularly extensive home office requirement, and so on. They, of course, put the burden on the functioning of the law firms, the insolvency practitioners, government agencies, and the courts. Not so much because they would have been closed or because hearings would have been canceled, because there are only a few hearings in insolvency matters, but we had in particular challenges because we're really lagging behind in terms of e-justice, as we call it here nowadays. So the whole filing, electronic filings with the courts, and the electronic dispatch of judgments by the courts and by insolvency practitioners and so on. So because we're so much lagging behind in that, the challenges were very practical. So you had to assure that despite the lockdown, you had enough staff in the firms and in the courts. You needed people that could sign documents, because we're still requiring the filing of really signed hard copies with the courts. Same for the courts; they issue judgments that have to be signed, not electronically, but that have to bear a real signature. So that were really the practical issues we're facing, and in other countries in Europe, they were really better prepared for that. For instance, in Italy, they had introduced a widespread electronic filing system already about 10 years ago. And also in France, they had already a functioning filing and tools, and so the effects were a little bit less. Maybe we briefly look at some specific measures that were taken in Europe during this first wave of the pandemic in spring 2020. So one of the measures that was adopted in almost all countries was the suspension to file for a debtor. So in case of over-indebtedness or illiquidity, this was particularly important in Germany, where not only there are strict legal deadlines within those you have to file, but there are even criminal sanctions if you do not comply with these filing requirements. In other jurisdictions, there were general legal standstill, so you had all the legal deadlines that were suspended, be it to file at the beginning of the proceedings or to file an appeal against the decision. In Switzerland, it lasted for 1 month, from mid-March to mid-April, and then it was quickly realized that such a standstill would, of course, block the entire economic life and could in itself put companies in danger if they could not enforce their claims against the debtors anymore for a prolonged time. Changes were also made to insolvency tests, so when you would have to file for insolvency, or the possibility to obtain preventive attachments were changed, payments periods were prolonged, and this was what I also would like to mention. It was some overlap with implementation in the national laws in the European Union of the EU directive on preventive restructuring frameworks, that in some countries at the same time this legal process was already underway and was then sometimes accelerated because this was also considered as a useful tool in this the crisis caused by the pandemic. But also quite to the contrary, for instance, in Italy, there has already been enacted a big big legal reform of the insolvency code that was on purpose, that was not enacted as initially provided for in summer 2020, but a year later, so in order not to create additional confusion with a new law in this period. To return to the situation in Switzerland, it seems to us particularly relevant that court proceedings are essentially in writing, so that the lockdown did not affect the hearings, which for some of them were simply postponed. And on the level of the administration of insolvency proceedings, there is also little physical interaction of the stakeholders. We will see that later regarding creditors meetings. So some of them were simply postponed during these first weeks of the pandemic.
Why don't we shift to talking a little bit about some of the general themes that we all saw across our jurisdictions. Hearings we hit on briefly, but I think we could talk a little bit more about some of the pros and cons of being in person versus virtual. Having witnesses and evidence entered into virtually had some of its own challenges. Denis, why don't you give us your thoughts on some of the pros and cons of that aspect of virtual hearings?
Well, virtual hearings, from my perspective, are great. It's much easier to schedule. What I do find is that counsel abide more by the time limit, which is determined by the court or which they commit to. It allows the availability of witnesses. Everything is easier. Easier to schedule, easier to hold. Really, it makes life easier at all levels. There's two elements that are more of a problem. The first one, in any given court hearing, lawyers get together just before the hearing, and very often some of the things, or everything sometimes, get resolved. Those pre-hearing discussions or corridor discussions are not taking place. And if you want to have those discussions, you have to commit to it. And some people are better than others at that. So that part of being together just before the hearing was very helpful. It no longer exists with the virtual hearings. The second thing is the witnesses. Of course, if you have a witness that has a short testimony, which is literally uncontested, then whether it's in person or virtual doesn't make a difference. If credibility is a big issue, it could be more complicated. We've had in Canada long trials that were held virtually from beginning to the end, where credibility was an issue, and both the judges and the lawyers at the end of the exercise were satisfied that it went very well. So it's a concern. It's more difficult to deal with. You have to prepare accordingly. But at the end of the day, it's something that you can deal with. And virtual hearings really are improving. And the fact that together with that, when it's not contested, you can have an order just based upon the documents filed, just like Benno was describing for Switzerland. To me, it helps having access to justice, and it helps basically the restructuring process, and to some extent limit the costs.
Right. One thing I really noticed was just the challenge of the logistics of dealing with trials and hearings while sitting at home. You know, it's never just one person who's arguing in front of the judge. It's usually the product of teams, information from clients, associates who have done research and have copies of everything to hand up, and trying to coordinate everything from a computer while listening to the judge's question, wanting to think of the next thing I wanted to say was particularly challenging. Yvonne,
what I would add on that is that, again, some were better than others in filing documents. Some of the documents came last minute, some of the written arguments came last minute, but I guess it all evolved during the 18-month process, and people are getting better at it, but especially early in the process, getting documents and showing documents on the screen was way more difficult, and it has improved.
I agree with that. And as you were saying, the challenges with filing, you also had mentioned to me at some point about just the increase in last-minute filings that happened with some of these hearings, and I would say last-minute attendees. One of the things that I think is great in the U.S. is, courts are generally willing to hear people out, even if they haven't appeared before and they haven't filed their pro hoc papers and they don't have anything on file. While somebody might be admonished for not following the rules, they generally get to have their say in court, and it's certainly much easier for someone to pop up on a screen for a hearing than it is for them to travel and make an objection. So while that leads to more people having their thoughts heard, it can also be cumbersome to deal with at hearings and hard to react to in real time while the hearing's happening.
And the same concept would apply to Canada. And I will say that judges were, generally speaking, even more lenient during the pandemic, allowing people to participate at the last minute, given that it was the pandemic. So, but you're right, it brings surprises that otherwise you could have dealt with, especially in those pre-hearing discussions, because you know who's there and you can inquire as to what the arguments will be, what the debate will be. Well, that has disappeared. I've seen judges put the hearing on mute, leaving the hearing for a few minutes to allow the lawyers to talk to one another. And he would resume, or he or she would resume 5, 10, 15 minutes later. And it's very helpful. So I think that's one of the practice that has been developed that is useful, and it replaces to some extent the pre-hearing discussions.
Yvonne, Mexico had some particular challenges as it shifted to virtual hearings. I think, isn't there some question now as to whether things that happen virtually are enforceable, and how do you think that will play out in the future?
Okay, actually, holding hearings was quite simple. With a total lockdown, you have no hearings. So it was quite simple. But the problem has arisen when we go to the mixture. You have to bear in mind that in Mexico, we have a mixed procedure that consists in procedural steps before the court and other steps that are followed within the trustee, that are out-courts acts. So all those acts can be taken place out of the court and do not have to have this ceremoniality that you have before the court. The problem with the hearings before the court has been that the actual courts do not have all the facilities to provide digital hearings. We are in this transition. The federal courts are quite evolving into this. It's still a problem because, as I said, we have a rigid scheme of law in which all the procedural acts or the formal acts before the court has to be with all the solemnity that they are requested. And having the virtual procedures do not enter completely in that scheme. Actually, electronic notifications are not allowed according to the law rules, but in the practice, the insolvency judges are allowed in it. So it's the same with the hearings. You have to be flexible to try to restructure or continue with the procedure, but you cannot be so tied to the law because Mexican law do not prevent that.
Mm-hmm. So questions for the panel. What are some of the things that you would like to see continue post-pandemic and that you think really worked well? I think, Denis, sounds like you're in favor of continuing with more virtual hearings going forward.
Oh, absolutely. I think it has been an improvement. It saves cost, it's more efficient. And once you get the practitioners disciplined to abide by some delays so you don't have last minute appearance or last minute surprises, to me, it has improved the insolvency system in Canada. And I do hope that it will remain. And I do believe that it will remain. And if we look at it from a more global perspective, if you have parallel proceedings in more than one country, it makes things easier. If you have intervenience in other jurisdiction or other countries, it makes things easier. So that's one of the, although I hate the pandemic and I hate the COVID, it's one of the positive things that came out of it.
And I think we could do more with technology going forward to try to create some of those virtual lobby, elevator, outside the elevator experiences that happened. You know, I think throughout, in the beginning of the pandemic, Zoom was just one room. And I think increasingly we've seen the ability to split people off, to have some of those sidebar conversations. You know, we've used them in mediations with success as well. There is that sort of critical time to be able to talk to people on the side about what may or may not be possible to get to a consensual solution. And I think that's something that has been missing in some instances and is a real area where we can innovate going forward to try to get back to some of the benefits of being in person, even when we cannot be in person.
And I think in having this part in person and part virtual presentation, I think we're showing that we can improve on that, and that applies to our daily practice.
Right. And Benno, in countries like Switzerland, where you have a lot of ruling on the papers, you know, do you think that's an area for innovation where more administrative hearings and uncontested things could be handled without hearings?
Yes, as I said, we have already really not many hearings in insolvency proceedings and also in the general civil proceedings. So I would even say that in normal times, I would rather keep what we have as hearings, because usually they are useful, as Denis said, you really to also to see each other and to allow these discussions prior to a hearing and after a hearing, and also to simply to meet in person from time to time, which we do not often in a court setting due to the functioning of our court system with paper filings. But of course, we should keep the possibility to have virtual hearings, and it may be useful in some situations also in the future to have them even without the restrictions of a pandemic. As Denis said, if we have participants from far away or that would otherwise not be able or not be willing to participate in a hearing, that could really be a benefit. For the time being, we still have the possibility to hold virtual hearings only in the emergency legislation adopted for the pandemic, and now the challenge will be that this can be transferred to the ordinary legislation, and so that we can keep it not only for the next pandemic but also for normal times if it is useful.
Hopefully there will be no next pandemic.
Yes.
Yes.
Yeah, also, as we discussed when we were preparing the panel, I do believe that this change is not only COVID situation and focus. In 2010, when we were prosecuting Mexicana de Aviación, you had plenty of creditors outside Mexico. And if you go to the Ministry of Foreign Affairs to have the notifications done, you will take 4 or 5 months. It was the first time I saw a case or a bankruptcy judge sending the email notifications, and nobody objected. So it's a matter of practice. It's not only the issue of or COVID. It's that today communications are worldwide, and we have to be prepared for that.
Right. Well, creditors meetings are another area that are very different in each jurisdiction. You know, in the US, we tend to have 2 main creditors meetings, one to form the Official Committee of Unsecured Creditors, and then the 341. I would view both of these as more informational. For the creditors committee meeting, and the US trustee is gathering information from the individual creditors to decide who should go on the committee. But that seems like something that's pretty able to be handled remotely. And 341 meetings are an opportunity for the company to present about its current state of affairs and where it sees the case going, and for creditors to ask questions. I think, generally speaking, it's probably a good thing for more creditors to be able to attend, get that information, and have their questions answered. But creditors meetings are used for different things all over the world, and I think this was an interesting difference between the jurisdictions and how COVID impacted the ability to get these meetings done. Denis, what are your thoughts on the pros and cons of creditor participation in meetings in Canada?
Well, creditors meeting in Canada are either in a bankruptcy concept or for a vote on a proposal or a plan of arrangement. in the two instances, decisions need to be made. So during the pandemic, creditors' meetings were held through various platforms, whether it's Zoom, Teams, or others. And when basically you have to deliver information, that's the easy part. Whether you have the report from the monitor or the trustee, whether you have the company that is addressing the issues, that's the easy part. Where it gets more complicated is when you have the questions. And typically, when you have a creditors meeting, you would want to know in advance of the opening of the meeting who will show up, what the questions will be. Some people will say try to work out the room to know what will come out of that meeting. When in a virtual meeting, you cannot do that. And you don't know until the meeting begins who's there. You don't know what the questions will be. Of course, you've had discussions with a number of stakeholders, but you did not necessarily speak to all the stakeholders, and often you have questions from the left field. Typically, it would make things easier if you were in person. You resolve the issue, you address them, and it makes for a smoother meeting. When you have a virtual meeting, it could go in all kinds of directions. At the same time, there's some frustration from the creditors because asking a question through a virtual meeting is more complicated, whether it's having a chance to express yourself or using the chat function. So it makes things more complicated. And where basically it becomes a real issue is when you need to have a vote. If you have voting forms that have been sent in advance, that's the easy part. During the meeting, you can decide to have the votes sent by email during the meeting. There has been attempts to have an electronic voting system that raises issue as to confidentiality and identification of the creditor and so on. But voting is an issue, and in those creditors meeting, decisions need to be made and creditors need to vote. So it allows people from far away to participate to the meeting. At the same time, it brings more surprises and it makes the voting part of the meeting more complicated.
Yeah, Benno, you really had that challenge in Switzerland, right? Where creditor meetings are not just informational, where creditors are making actual decisions in the meeting and coming out of the meeting about who the administrator would be and who the creditor representatives would be. Can you give us an overview of how that has worked? How it works normally and what the challenge was?
In Switzerland, we have also both types. We have informational meetings, but we also have very substantive decisions to be taken at creditors meetings. In particular, the choice of the trustee liquidator and of the creditor representatives, the members of the creditors committee, and also decisions about the way how to realize certain assets. For instance, our bankruptcy code is quite formal in the sense that assets are to be realized by public auction, and if they are to be realized in a more modern way or in simply a different way, there needs to be a vote by the creditors on that. So in most of the proceedings, this is not an issue because there are no creditors meetings. Decisions are taken by circular letters. But in the bigger bankruptcy cases, so the liquidation cases, and in the restructuring cases in general, meetings are mandatory. And unlike for court hearings where the missing authorization to hold virtual hearings was corrected by emergencies legislation, this was not done with regard to creditors meetings. This was just not in the focus of the legislator. And the solution was found, although not tested in court so far, by reverting to the legislation, the emergency legislation that was done for shareholders meetings, where the legislator immediately saw the need to allow virtual meeting and even to oblige companies to hold virtual general assemblies. And so far, the Swiss administrators in restructuring proceedings referred to this regulation on shareholders meetings, and no one has challenged this in courts so far. The advantage was, of course, that in the restructuring proceedings, contrary to the bankruptcy proceedings, no formal decisions were to be taken at most of these meetings, at least. So they were purely informational meetings. So there was no real incentive to challenge that in court. For the formal meetings, yeah, at the beginning they were simply postponed, and later on, the bankruptcy trustees, they tried to organize it by way of pre-registration, so that the caps for the number of people that could attend were upheld and followed. But of course, this was not a solution for larger meetings and large bankruptcies. But as I said, so far, no challenge has been filed, at least it has not been published, not come to our attention. So we will see whether the ordinary law, the Bankruptcy Act, will be adapted to that. I hope so, because in this field, maybe even more than for court hearings, the virtual organization of creditors meetings has really proven to be very useful. Or maybe in the future a mixed organization, because it will allow creditors from abroad, from other countries, but also from different parts of Switzerland, to attend meetings that otherwise they might not be attending, because traveling 2 or 3 hours just to attend a meeting where maybe there's not much to be gained is often, of course, not a priority for a typical creditor. And yeah, the main issue is, as I said, is really the voting. In the meetings where voting and elections are to be made, we know that these systems that Denis mentioned, the tools, Zoom and others, they offer such possibility. But of course, there are issues of secrecy of the votings. There are issues of the access control. You need to know who is attending the meeting, because there are also some minimum attendance requirements. And creditors can show up at the last minute. So this may be not sufficient to send out access codes in writing before, because a creditor can produce his claim, just show up with his claim in hand at the meeting and ask to be admitted, which has then to be decided on the spot by a small, what we call a bureau, an office. In the assembly. So these practical and also legal challenges, they are still ahead of us. I think that just not enough time that has passed and not enough meetings that have taken place where these questions have come up.
Yeah.
But Lisa, if I may, I think that one of the challenge going forward is now it's easy because we're all virtual. So all creditors, all attorneys will be attending virtually. As things evolve, to have people in person and others virtually will be a big challenge. And I think that the participation of those that will only attend virtually could be or should be limited.
Creditors meetings play a big role in Mexico restructurings. How was that challenged during COVID?
Yes, in Mexico, we do not have the creation of committees as pursuant to the instruction of the law. The committees are privately, and you have to bear in mind that, as I said, there are some parts of the procedure that are prevented to be taken out of the court. The recognition of the credits, the negotiations, and the achievement on an agreement, of the signing of an agreement, is prevented to be doing before the trustee. So this scenario gives some flexibility to handle these sort of things. And all these negotiations and the committees and the private restructuring are made within and in co-work with the trustee. And after that, everything will be submitted to approval to the court. So this gives a lot of flexibility, and it has been a lot of in Zoom meetings. That's how it's been doing, but still having presential or in-person meetings as well.
So when we talk about the legislative impact on restructurings in this time, it seems like there were countries where quick legislative action, changes in regulations really helped things to go more smoothly, and other jurisdictions where some action might have really helped save businesses. What are some thoughts that people had about some of the pros and cons of the legislative action during this time?
Well, if I look at some of the things that were done in Canada, to me, one of the prime example was the order that was developed together with the Canadian Association of Insolvency and Restructuring Professionals, the Insolvency Institute of Canada, and the National Judiciary Working Force, where people rapidly realized in March 2020 that time was flying, things needed to get done, rights could be lost as a result of the lapsing of time. And basically, together, we developed an order that was first rendered by Justice Morovitz, that was then issued in every single province, basically giving more time for people to do things, to file proposal, to have creditors meeting. Really, the judiciary, to that extent, has done a tremendous job. The Office of the Superintendent of Bankruptcy did the same thing. And the courts, in rendering the orders, have basically been flexible. And for those that have been in contact with the CCAA, the inherent jurisdiction of our courts was properly used to the benefit of the restructuring and insolvency. So the legislator, the judges, the various associations all came together and basically gave the tools to be able to go through this difficult period. I truly hope that this working together will continue, because it's been of a great benefit to all of the insolvency practitioners and the debtors and the creditors in this country.
Yeah, in the case in Mexico, unfortunately in our country, it's difficult to go into an amendment for the law. It's a bit difficult process, but in 2011, it was a constitutional amendment that was approved and prevent the courts to make modifications to legislative process in fact. So you don't have to go into the whole process of creating a law. The courts can amend the application of some parts of the law, and most of the practice has been doing in this way. The courts are complementing or substituting the facts that are not functioning correctly in the law, but going into an amendment, it's very difficult. Actually, a preventive or emergency regime was submitted by some practitioners in Mexico at the beginning of the pandemic, and it hasn't been even a study in the Congress. So.
One of the things I think is really interesting, and especially for an organization like ours, is the impact of sort of the differences between countries and how they're reacting to the changes in the situation. And, you know, we had instances where countries were issuing moratoriums that prevented, you know, that removed the requirement to file, but those moratoriums were of different lengths. And the reality is that very few companies operate in only one country. And as we look at global corporations and global restructurings, you know, did those moratoriums really achieve what they were meant to achieve, which is to give a breathing spell to companies, or were they forced to just follow the jurisdiction that had the most restrictive moratorium and file at the earliest time to avoid tripping those issues. You know, I think, Benno, I'd love to hear your thoughts. The EU is certainly probably the best example in the world right now of countries attempting to have some level of coordination amongst their different legal systems. But how did that play out? And was there coordination during the COVID around legislative and other issues?
Yes, I mean, at least the European Union tried certainly to coordinate the reactions of the member states to this pandemic. Of course, the competencies of the EU in the field of health and the related measures, which is at the core of the pandemic, of course, are quite limited. So there was not in all fields there was a lot of room for the EU to act. And also in our field, in the insolvency field, it clearly showed that despite the regulations the EU has enacted for cross-border coordination and so on, and which really have a big influence on Europe, in the end, it all falls back on the national insolvency laws and regulations. And the details in these regulations. So the measures were taken on a national level. But as I mentioned at the beginning, when I summarized a little bit the measures taken, in the end, of course, the needs are the same everywhere, and depending on the specificity of the legislation, the responses in the end were the same. So you had suspended the duty to file. The legislators had put additional protections against bankruptcy petitions by creditors and so on. And also some legislators were quite creative. They tried to introduce new tools for the economic difficulties that were expected and that in the end, as we have all realized now, may have not been as acute as it could be feared at the beginning. Of course, mostly due to the heavy economic support that was provided by all countries. For instance, in Switzerland, with a lot of support and also input from law firms and other practitioners, a specific moratorium for small and medium enterprises was created because before the pandemic, the small and medium enterprises did really only very rarely resort to restructuring proceedings. And this moratorium was in our view, was a good thing, but things went so well after the first months in summer and at the beginning of fall 2020 that this emergency moratorium was not continued after October 2020. And maybe this has proven to be the right decision, because even now, until now, things went pretty well economically and have now restarted. And the sectors that were most affected, like tourism and restaurants and so on, they got so much support that there was not real a wave of bankruptcies and insolvencies. So this moratorium, which was created from the outset, the special moratorium, COVID-19 moratorium, as it was called for small and medium enterprise, actually was only in place for 6 months. And yeah, maybe it could be useful in the coming months. We don't know what happens now when economic support will slowly fade out and stop. But yeah, it's an example of something that has been created in these weird times in spring 2020 and which has not been used as expected. There were about just 23 or 24 cases in 6 months. And but it's still there. It's on paper. It could be reenacted if necessary, and maybe it should even be introduced in the ordinary law.
So my last question for the panel is, where do we go from here? You know, we are an organization of global restructuring professionals. I think we've seen, and some of the other panels have highlighted, some of the challenges that happen with enforcement of proceedings in different jurisdictions, and then we end up having to have multiple parallel proceedings or recognition of proceedings across multiple courts for the same restructuring. You know, are there things that have been implemented in COVID that you think could be a benefit to us going forward, that could enable more coordination between jurisdictions, between judges in these types of proceedings?
Absolutely. I mean, we have the ancestral model that has been adopted by a number of countries. I wish I could say all countries, but it's been adopted, sorry. And with those virtual hearings, with those virtual creditors meeting, I think that it should allow, and we all have to work together to make sure that restructuring that really take place globally, other than a convenience store, there's really very few corporations that have either operations or assets in only one country. And I think that what has emanated from the pandemic are tools that we should be using to work together and to bring the jurisdiction to work together. I mean, I've said in the past that I've seen a court hearing with a Canadian judge and a US judge sitting together in the same courtroom. Well, now there's no need to go to the same courtroom. You can do it virtually. And I think that's a tool that will be very helpful going forward, and we should build on that.
Any other thoughts on that topic?
Yes, certainly. I do believe that the main experience or the learning that we have from the COVID in Mexico is that we have to be dynamic, because the rigid form of going into the legislative process or attending court procedures or so on, reorganization companies, we realize that we cannot expect that law give or prevents all the solutions for the economic problems. Nowadays, in this globalization area, you can be doing business in the morning in America and in the night in Asia. So you have to be prepared for that. And that's something that will be staying for long us.
I think we have a few minutes left for questions, if anyone has any in the audience or...
Well, Lisa, there was a question, I guess, that will be directed to you in the chat box, which is, what about the US practice in the COVID area? It's a short question. The answer could be more complicated. I'll defer to you.
So I'm sorry, but it broke up a little bit. So what was the US practice
in the COVID area? How does that evolve?
You know, I think that things have evolved very smoothly. As I said at the beginning, we switched very quickly to online hearings. The judges have been extraordinarily accommodating to allow for emergency hearings and relief, and for whatever was needed. I think we're able to continue our work pretty seamlessly. So it was a real benefit here.
Are there other questions in the audience here or on chat? So I have a question for the panel. In discussion among bankruptcy judges in the United States, on the whole, people are pleasantly surprised by how well remote hearings have worked for many things. And I think there are discussions, informal discussions going on about what we will continue to do after COVID passes. From my own standpoint, I think there are clearly hearings that I hold where it would be better economically and otherwise to continue to do them remotely. One of the things I think that judges in the United States, and I suspect judges elsewhere, would be interested in hearing from the bar, from organizations such as the III, is to what extent should we be able to modify our practices pre-COVID to continue doing things that have worked well during COVID? And so, you know, Dennis, you talked about joint hearings. Pre-COVID, I had a joint hearing with Justice Morowitz in Toronto. He was in his courtroom, I was in mine, and there was live video feed. We each heard arguments from lawyers in our respective courtrooms. That worked well. That was pre-COVID. I expect that'll continue in the future, but I don't know, Lisa or any of your other panelists, are there things that you think judges should do in trying to incorporate more virtual or hybrid hearings going forward? It may require rule changes in some courts. There is authority in the Federal Rules of Civil Procedure in the United States that permit remote hearings if circumstances support it. Mm-hmm. But I don't know whether any of you, whether you or your panelists have suggestions.
Yeah, I'm happy to take the first shot at that. I mean, I think that enabling omnibus hearings to go forward virtually would make a lot of sense. We often have things that are uncontested or require very little argument to go forward. At those hearings, it would be cost saving and time saving for the professionals and for the estate. We already have situations where most courts require evidentiary hearings to be scheduled separately. So you might use virtual hearings for the status conference on the evidentiary hearing and to resolve discovery disputes, but have the actual evidentiary hearing or trial happen in person, where some of that, that lobby negotiation becomes most important. When you see the way it's trending, you see how your witness did, you see how the judge is reacting, that real time, I think, benefits from being in person. Fee applications are one I think definitely could continue virtually and save the estate money.
Oh, I love to have the lawyers appear before me and argue in support of their fees, but.
Yeah, so I think a hybrid situation where some things continue virtually and some things are in person might work well.
Some people have expressed concern with hybrid hearings that the lawyers who actually appear in the courtroom will have an advantage over those who are appearing
I
remotely.
agree, and I did not mean to suggest a hybrid hearing where some are in person and some are not. I meant more of a hybrid case where some of the hearings happen entirely virtually and some of them must be in person, and maybe case procedures motions at the start of the case could be used in the first instance to try to sort some of that out before formal rule changes are made, but I don't know if that's feasible.
Dennis, what do you see happening in Canada after COVID passes? Do you think the courts will continue doing things that they've adopted during COVID?
I do believe so, but let me go back to your last question. I was making the comment about creditors meeting earlier, that being in person and having others virtually is an issue. I think it's the same thing for the court hearings. But there are things that have changed in Canada that will remain, and I think that the practice will be improved from that.
Are there any other questions in the audience? Lisa, you and your panelists have dealt with what we've all been struggling with. For me, it was educational because I see what goes on in the courtrooms, but I don't know how you've effectively incorporated remote virtual matters in creditors meetings and things like that. So that was very enlightening to me as well. So let's thank our panel. We are at a lunch break until 2:15. Then we'll resume with the panel that I'll be moderating on deconstruction of a cross-border case. What I would suggest is, if you can, we have a long hypothetical which is posted with the program materials on the app. It's actually the second item in the list. It would be helpful if you could review the hypothetical before we begin the program, because the program is an hour long. It's a fairly lengthy hypothetical. It raises issues in Brazil, the United States, and elsewhere. So we'll deal with that starting at 2:15. Thanks very much. And lunch is downstairs. Yes. What Sherry has just pointed out, we had some hard copies made of the hypothetical on deconstruction of a cross-border case, and they're out on the desk outside if you wish to take that rather than read it on your